Good morning and welcome to today's webinar, Understanding Estate and Trust Administration, presented by Elville and Associates, Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be moderating today's event. So how this will work today, if you're new to our webinars, if you are, welcome, we're glad you're here. If you're coming back to see us again, thank you as always for your support of our webinar series. So you as the attendee are currently in listen-only mode. However, if and when you have questions, please note them in the questions panel on the right-hand portion of your screen, and we will take time throughout to address them. Your questions really add value to the presentation and help others learn, so please don't be shy in posing your questions to us at any time. You also received the presentation and two checklists. They look like this right here, if you can see that, from me by email this morning to take notes on it if you wish. If for some reason you did not receive these documents, they are available in the section marked handouts on your screen to download at this time. I especially encourage you to print out the checklists if you would do that at this time. For CFPs, CPAs, and other professionals on today's webinar, welcome as well. You may receive 1.5 continuing education hours for attending. And per my attendance records requirements as usual, please email me your ID number. And for CFPs only, I also must have the last 4 digits of your social security number as soon as possible so I can submit your CE hours for approval, which I will plan to do on Monday. Everyone will also receive a post-webinar feedback email right after the presentation. And we ask that you please just take a couple minutes to fill out this very simple survey, offers your feedback about the presentation, and we read and value every comment. It's also an ideal time to request a consultation with Steve for any planning needs that your family may have now or in the future, and we always look forward to being a resource to you here at Elville and Associates. So briefly, as we have a lot to cover as always, I'd like to offer you an overview about our firm and share a little bit about Steve if you're not familiar with this. So Elville and Associates, you should be able to see my screen here. We were founded in 2010 in Columbia by Managing Principal and Lead Attorney Stephen Elville. We have a number of different practice areas that we focus on here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, tax planning and asset protection. We have 7 attorneys, 12 staff members, and 5 locations. Steve and I are coming to you live from the Columbia Gateway Community location today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we do focus on education here at Elville and Associates if you haven't figured that out already. We do that in many ways through our planning processes with our clients, through over 100 educational webinars and workshops in the communities that we serve each year, and also by way of our accredited client care program, or CCP as we call it. We're one of only 2 firms in Maryland to have an accredited CCP through the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day. A little bit about Steve. His work as an attorney for the past 20+ years has been centered in elder law, special needs planning, and estate planning with an emphasis in the areas of tax planning and asset protection. A member of many different national membership organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys, among many others. He works to bring peace of mind to clients by creating solutions to the needs through counseling, client education, and the use of leading-edge legal technical knowledge. A very seasoned speaker, if you haven't heard Steve present before, presenting at many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. Also, Steve was named to the Maryland Super Lawyers list for a 7th time in 2022 and a 6th consecutive year. So congratulations to Steve. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014, and I'm privileged to be the executive director of. So if you'd like to learn a little bit more about the Elville Center and how we work to make a musical difference in the lives of children each day, please reach out to me and I'll be very happy to share our story with you when we have just a little bit more time. But for now, we're going to go ahead and get started. And I'm going to start off with a brief poll, as we like to do sometimes. And it talks a little bit about what has your experience been with estate and trust administration to date. So make the selection that best suits your situation, if you would, so we get to know who's with us today. And the choices are: 1, I've been the executor of an estate in the past on my own. 2, as an executor, I sought professional guidance throughout. 3, I may be asked to be executor of an estate in the future. 4, I want to keep my planning in order to keep costs down. And lastly, number 5, I am an advisor here to learn to better serve my clients. So thanks for participating and being here. I'm going to turn it over to Steve in just a second. It'll take just a few more seconds here. Okay, it looks like those who want to have participated have. So a varied group here today, Steve. We have 14% say I have been the executor of an estate in the past on my own. 11% say as an executor, I sought professional guidance throughout. 14% say I may be asked to be executor of an estate in the future. 39% say I want to keep my planning in order to keep costs down. And lastly, 24% say I am an advisor here to learn to better serve my clients. So thanks for participating. Steve, I'm going to go ahead and make you the presenter.
All right, Jeff, thank you.
And you should see that button pop up there. There we go.
All right, and I should be able to get right to my presentation, start the slideshow. Thank you, Jeff, for that wonderful introduction. And good morning, everyone. It is Friday. Thank you for spending your Friday morning. Your time is very valuable. Thank you for spending that with us. Welcome to our quarterly estate and trust workshop for administration. It's a beautiful day outside. I'm here in conference room number 3 at Elville and Associates, looking out the window here on this beautiful day. So I hope you have a wonderful day ahead and a wonderful weekend ahead. And I'm excited this morning because this is one of our most important workshops. And what I hope to do today is convey that excitement to you. And you may say, well, how could you be so excited about trust and estate administration? Well, it's because I know from our experience that trust and estate administration is the third stage of the process of estate planning. In my view, we have 3 major processes in estate planning. We have the design and implementation phase, and that includes the design of an estate plan and the funding and alignment of assets in that plan. But we also have then the maintenance and the lifetime upkeep of that plan. And then we have the final administration of the plan, the maturity of the plan. And that's what we're going to talk about today. Jeff, my longtime colleague and friend, is a wonderful webinar moderator. Please feel free to ask Jeff questions. If you're having technical difficulties, please let him know. And we're going to stop occasionally throughout this webinar to answer questions. We can't render true legal advice on the webinar, but we can provide general answers. And what I hope to do today is give you what I would call a mini masterclass that really is the compilation of my experience in estate and trust administration. I'm going to be sharing with you some concepts. I don't expect you to remember every single thing, but I would want you to take this webinar material, take this presentation that Jeff has made available to you, and use it as a tool. Because not only is it a compilation of my own experience, but it's a compilation of my observations of some of the best estate and trust administration attorneys I have ever known. So I think in that light, it'll be very helpful to you. So again, thank you for being here. We're going to be efficient. We're going to go ahead and get started here. So as we set the stage for this, I would like you to just slow down for a second and consider that someone who really administers an estate or trust, and by the way, I did get the feeling from Jeff's survey that many of you have come for different reasons. Maybe you have experienced a recent loss of a loved one. You want to save money in your estate planning overall, or you anticipate being a trustee or an executor, a personal representative. Whatever reason you're here, whether you're an advisor and you're here, for whatever reason you came today, we not only appreciate it, but we understand that you're coming from different perspectives. So with all of that said, I would like you to imagine that you're getting ready to administer an estate or a trust, and you're a very conscientious person, obviously, and you want to do the highest and best thing. So in that regard, I would like you to imagine just for a moment, whether you like classical music or not, or contemporary music, that you're a conductor. You're conducting an orchestra. So as the trustee or executor or personal representative of an estate, I like to think in terms of you are getting ready to orchestrate a process. You're getting ready to orchestrate a symphony, and there are various components of that symphony. And without getting too much into the analogy, you are directing, and you're very important to that process. You've done a lot of preparation, which is why you're here today. You're getting ready to lead this wonderful orchestra through a complex series of events that comprise the music, so to speak. Another analogy, if that one doesn't resonate as much, is you're an artist. Let's pretend that you are an artist. And what do we know about art? Well, there's different types of art, but most professional artists, and I happen to be married to one, but most professional artists take a lot of time in setting up their work. They set up their composition. Whether you're a photographer or whether you paint in oil or whatever your medium is, the person who is the real artist takes time to compose and to get ready. And that's what we're going to do today. We're going to kind of imagine that we are doing that. And I think that will set the stage for what I would call the beauty of trust administration, how it can be orchestrated, estate administration, how it can be orchestrated in a very coordinated, very logical fashion. And of course, that's not always the case. And of course, when people pass away, we don't always have everything in complete order. We don't want that, and that's why we're here today, to try to talk about how we can have our affairs in good order. But with all that said, we are going to use some tools, just like a conductor of an orchestra would have his or her own set of tools, and music, the master sheets of music. We also, in art, we have tools and materials. Well, our materials today are going to be these checklists. And Jeff has made sure that you've known what these are. These are critical date checklists. And I kind of want you to think of this as your sheet music, so to speak, for today, in the analogy of the conductor or the musician. Here's one for estate administration. The other one is for trust administration. And there are various checklists and tools, but the idea that I'm conveying here right from the beginning is that we are going to be looking at a process. And that's why this webinar is called the post-mortem process, because it is a process, and the more you look at it like that, the more organized it will be, and the least stressful it will be. All right, well, thank you for that as I made my introduction. And now we are going to move into the next slide. Jeff, I apologize. It looks like I'm having a little bit of computer problem here. And with everyone's permission, I will, it looks like I may have to reboot my computer. I apologize, and I will be right back very shortly.
Well, while Steve's rebooting his computer, sorry for the inconvenience there, but I'm sure he'll be back in just a second. just to make good use of our time, just to let you know what's going on in our webinar series, which I normally do at the end. Next Wednesday, we're going to be talking about the uses and purposes of irrevocable trusts, which we did earlier this year, and are bringing that back. That's on Wednesday, the 28th, with Steve. And on October 5th, Lindsay Moss, our senior elder law attorney, is going to be talking about guardianship, what it is, when is it appropriate, and what are some alternatives. And then on October 6th at 10 o'clock, we're going to be talking about financial exploitation, frauds and scams targeting seniors with Officer Andre Lingham, formerly of the Howard County Police Department and the Officer of the Year in 2014 and 16, I believe it was. So very pleased to have him back for that presentation that was extremely popular back in the spring. We also have our advisors forum for our financial advisors that we're having back in person at Oakland Manor on October 12th. And then on Tuesday, the 18th, always the third Tuesday of the month, we're bringing back our Elville webinar series, Wellness Series, which is installment 12 of that series, Know Your Why, Fulfillment versus Busyness. And that Wellness Series, if you haven't taken part in that yet, is getting extremely popular. We had about 85 people on that presentation this past Tuesday, and it was just a great discussion. And we have that on our YouTube channel in our webinar recordings if you're interested in viewing our recent presentation. So that's a little bit going on in our webinar series, and really appreciate your continued support of the webinar series. So it looks like Steve's back, and we're going to turn it back over to him.
All right, Jeff, if you could share your screen again, I think, unless you've already done that.
Yeah, let's go ahead and do that. Yeah.
My apologies, everyone. I am back, and the technology seems to be working. All right, and we should be right back where we were before. Again, we're going to get started now. Thank you for your patience. So today's presentation is going to be about unraveling the mystery of what happens after the death of a loved one. We're going to be talking about minimizing confusion. We talked about that just a moment ago, and providing support to people who are in crisis. This could be from the perspective of an advisor, from the perspective of a family member, from the perspective of a trustee or a personal representative who is not a family member. We're going to look at the legal process of what happens after someone dies, but we're also going to look at the practical steps, and we're going to look at the most problematic legal and tax issues that professionals, whether they're advisors or someone serving as a trustee or an executor, should be aware of. And we're going to talk about how the advisory team, let's talk about the CPAs, the advisors, the attorneys, how can they best work together? And we know that this can sometimes be very problematic. So as we get right into the material after that slight delay, one of our clients, and if you're a professional in this webinar, one of your clients' greatest concerns is about this mystery. If we were to take a poll of people around the United States or maybe even around the world, the number one question that many people have about estate planning is, what happens after my death? In particular, with a revocable living trust, what happens after my death to my trust? So this is one of the biggest concerns, and we're going to go into this administrative process that we're going to talk about. With wills, which have to do with probate, for example, probate is the process of proving a will to be valid. We have an administrative process overseen by the Register of Wills in Maryland. Now, in other states, my understanding is in certain states like Virginia, the probate process is more minimal. But in Maryland, we have a more traditional probate process, and that typically is about 9 months. It's not always 9 months. Sometimes it's more than 9 months. It is just a question of whether there is regular administration, modified administration, whether there's a small estate, or whether there are complications that take the estate into another year, 9 months, 12 months. Apologize, looks like I have more computer problems here, but we're going to quickly dispose of those. All right. And now we have trust administration. And trust administration, as we're going to talk about, is very similar in concept to estate administration. So no matter whether we are administering a will or whether we're administering a trust, we are still going to be looking at an administrative process, although revocable trusts have certain advantages. And I call that the transitionary period. So no matter what happens upon the death of a loved one or a death of an individual, whether there's a probate process or whether there's a non-probate process, we have a transitionary period. So we want to talk about who is going to be there for the surviving spouse. What can the executor or personal representative or trustee do? And remember, we want to be driven by process. We don't want to be driven by circumstances. We want to be organized and educated. So as we get into now more of the meat of the discussion, I'm going to show you some case examples. And in past presentations, I have spent quite a bit of time in explaining these examples, but today I'm going to spend more time on the process and not so much the examples. And if you would like to get into more details about specific examples that you may have or that you may see here in this presentation, I'll be glad to do that with you at another time. But I'm just going to give you an overview of certain types of situations and case examples that you could encounter. And of course, there are plans where it's very clear what's going to happen. Then there are plans that have a lot of retirement type assets. And we know since COVID, we know that at least on my side of the fence, that we deal with a lot of different changes with financial institutions and their views of how retirement plan assets are titled and the strategic use of non-probate assets. We sometimes have situations where it's very specific that everything was geared toward a survivor or a surviving spouse, and the situation is different than anticipated. And then, of course, there are situations where there's no planning at all. So let's just go into some of these fact patterns. And again, we're not going to drill down as much as we normally do in this presentation because I want to focus more on the process. But we do need to kind of be aware that there are different situations that every professional or executor or trustee will encounter. Here in this example, as we look through the death of a single person, and that person has one child, is there anything that really pops out? We're not going to really get into great detail here, but the first thing that pops out to me is there are IRAs, so those are going to have death claims, and we're going to talk about the process of claiming IRAs and retirement assets in just a little while. Savings bonds, these present certain questions. These are usually subject to probate, and they have to be taken into consideration. So in this example, we have a single person with an only child. Very straightforward. The person had a will, so certain things are going to be subject to probate, like the residence, like the savings and checking accounts and CDs, and the savings bonds are going to be subject to probate. But the retirement asset, which hopefully is beneficiary designated, will not. But the two things that pop out here that you should be aware of are the claiming of IRAs and how to deal with the savings bonds. In this next fact pattern, we have a married couple who, a slightly older couple. There is a surviving spouse. One of the spouses has died. This is a fairly straightforward situation most of the time. There is a revocable trust plan here if you look down to the bottom of this illustration. And so the survivor in that revocable trust has everything outright to her. So here we have a very straightforward situation. If the person who died, the decedent here, his name is Jack, if he had used a more complex type of arrangement, a formula clause, there would either be a marital or non-marital trust set up at the time of his death for the benefit of the surviving spouse. Here we have 3 children. We don't see any problems. There are no creditors. So what pops out to us? Well, we have IRAs, and those IRAs need to be claimed. There is a joint brokerage account that's very straightforward. There is a Delaware residence in this example. So there is going to be an asset in another state, but because everything is going outright to the survivor, there's really no big issues here. We'll get into more details about the process, but I just wanted to give you a few examples just to kind of get your ideas and your thoughts going about administration. In this next example, we see that 20 years later, the surviving spouse dies in the same example, but we have a disabled child. There are situations that have changed over the last 20 years. This is one of the reasons why we have to keep our estate planning updated over the years, because obviously things will change. The residence has changed, so what pops out here? Well, the survivor is in the continuing care retirement community. There's a deposit there that has to be dealt with. There's a rather large IRA. The Florida residence now, during the last 20 years, the survivor had purchased a house in Florida, so they must have sold the Delaware house. So changing circumstances, but here, because we have a revocable living trust, and because hopefully the Florida house and the former Delaware house were titled in the trust, there is no probate in either state. So again, a different scenario. You're going to have a variety of scenarios you're going to be dealing with. We're not going to spend too much time on this. I'm just pointing out the obvious things to be concerned about. One of the things here, before I go away from this slide, is we have a child who is now disabled. This is an adult child, and we want to hopefully have enough flexibility in the survivor's trust to deal with this, that there might be the possibility of being able to do a special needs plan for that person with a traumatic brain injury, even though, again, this is all subject to whatever was provided for in the documents and the type of legal help that would be needed at that time. Our last quick fact pattern is just a married couple who happens to be separated. The person who passed away has no will. What are the things that pop out here? Well, there's an inherited IRA, so hopefully that would be further beneficiary designated, and there has to be a claim on it. There is savings bonds, so those savings bonds go through probate. Life insurance without a beneficiary goes through probate. And look at this. This gentleman had died and left lifetime gifts. We're going to be talking about the different types of taxes before we wrap up the presentation today. So lots of different types of situations we're going to deal with. I'm going to focus again mostly on the process today. Now, we want to, as we mentioned earlier, minimize confusion through planning. We want to be prepared, okay? And we want to provide the maximum support to the individuals who are the survivors at the time of crisis. So the number one thing, arguably, is for the person who is the trustee or executor or personal representative, and for the professionals involved, is to have empathy for the survivors and for the fiduciary for their situation. Now, we want to have this kind of empathy in various ways. It's not going to be helpful if we simply are very empathetic. We also want to provide a path forward. We want to provide family support. What kind of family support does the client need? What is their family situation? If necessary, we have to have the whole firm involved. So if you're a professional on this call, you have to have your firm involved as a whole. We have to have support staff. We have to have professionals understanding the kind of situations our clients are dealing with. Now, we have to be creative as well. And if you're a professional on this webinar, we want to make sure that we're very educated about resources, and we make it our business to make resources available. If you're a non-professional on this call and someone who is anticipating being a trustee and a fiduciary or an executor, you want to educate yourself about the resources that you're going to need to have available to you. And you want to have this ability to reach out and get those resources. And we can talk more about that, or you can help offline. We can talk about the kind of resources that would be ideal to have in your back pocket. Now, one of the things we routinely see, and you will see this if you are a fiduciary, you're going to see that the survivors are going to feel in many cases that they have to be in a hurry. You're going to see them in a very painful situation, and many of you have seen that. So we want to be assuring, and we want to tell them that in most cases, there's really no hurry. There's no reason to have to put ourselves through a lot at an emotionally draining time. Now, with that said, there are some circumstances. Let's say someone passes away and they had been a successful real estate investor and they've got lots of properties and they've got lots of tenants and the pipes have to be fixed and this tenant over here had a problem. Well, obviously there are things that many times have to be taken care of immediately. But generally speaking, with the exception of those types of things, we want to just tell the survivors that they do not have to be in a hurry and they should take care of themselves. Now, we also want to work as a team. So I know we have various types of interests on this webinar. So we want to assure the fiduciary that all the advisors, all of the professionals involved are going to be notified and that they are going to be coordinating together. So one of the challenges, and I'll just stop here for a few minutes, one of the challenges is the advisory team. The advisory team, as we often say here at Elville and Associates, is this team of advisors that needs to be there for all clients: the attorney, the CPA, the financial advisor, perhaps the insurance professional, and in the case of people who are aging, life care managers. So we want to make sure that everyone involved is not only coordinating together and working together, but that they've been notified, and there's probably going to have to be a leader of this group. So what I would suggest is for all people who are considering the idea of administration, that not only do you gather your ancillary resources and your information ahead of time, but that you make sure that your advisory team or the advisory team of your loved one is prepared, that they are willing to work together, that they are willing to communicate together, and that they are willing to expedite the process together, because this can be the source of many delays and problems and gaps of information. So we want to make sure that this wonderful thing, this advisory team, is actually working together. And I think that is best done on a case-by-case basis during a person's life. So we want to make sure we have a team and that team is working together. We want to assure the survivors that everything is in order, and hopefully it is. And if everything is not in order, then we need to make sure that we are doing everything we can to organize as best as possible, as soon as possible. We want to make sure that funds are available. So many clients will say, gosh, what should I do to ensure that funds are going to be available? Do I set aside certain funds? How do I know that my fiduciary is going to be able to get their hands on, get access to money that my survivors may need? So this is a counseling issue. We want to make sure that we're helping our fiduciary or the survivors, I should say, with final arrangements. Final arrangements can be somewhat difficult. I would suggest that people make advanced arrangements. It's not always appropriate. Funeral homes, cremation services, they have to be paid. As executors and fiduciaries, we want to make sure that these professionals and funeral homes and so forth get paid. This can be a source of frustration. The Register of Wills is very big on this to make sure that these institutions get paid. And of course, that's the highest and most important priority, and that's why the Register of Wills puts that as a highest priority. As professionals or fiduciaries, we want to make sure we are sending flowers and others, recognizing other expressions of sympathy, and also attending a funeral or memorial service. This is very important, that all people involved are empathetic and working together. Now let's get into the legal step-by-step process of what needs to happen at death. We're going to be talking about probate versus non-probate. We're going to be talking about why and how they are similar but different steps and different processes. We want to use our checklist, and this is just one example of the types of checklists that you can use. And we also want to always keep in mind, as I mentioned earlier, organization is the key. Organization and orchestration is really the key. All right, let's talk about the legal step-by-step process that takes place at death in probate. So let's talk about probate just to situate ourselves appropriately in the mental framework. Probate is the process of what? Proving a will to be valid. Now, If we have no will, just like one of the examples there, that gentleman died with no will, what happens? Well, we can still have probate. We can still have probate if there are probate assets. So let's talk about what probate assets are. And I realize I'm talking to probably a very educated group, so I apologize if this is too simplistic. Probate assets are assets that have no joint owner, and no beneficiary. So let's say that I have a property that's in my own name. It is in my sole name. It has no joint owner. It has obviously no beneficiary, so to speak. So that property at my passing is going to go through the probate process. In Maryland, there is this 9-month usually process, sometimes shorter, sometimes longer, that is the proving of the will to be valid, and my probate property would have to be probated. It'd have to go through that process, and that's what we're going to talk about now. If I had no will and I still owned that property, it would still go through probate because my estate would be governed by what? The laws of intestacy, the laws of intestate succession, where Maryland would say, this is how my estate is distributed, rather than me, because I did not have a will. So there's a date of death, and there is a death certificate, obviously, that is issued. Then there are letters of administration. That's what we call it in Maryland. These are the official letters that have a raised seal on them. This gives your personal representative in Maryland, it gives them the ability to take control of your assets, and that's very important. They're going to marshal the assets, as we call it. And as they do that, they are going to do one of the most important things. They are going to get the date of death values. They're going to have tangible property appraised. They're going to have real property appraised. They're going to get the date of death values of retirement plans and non-retirement plans, brokerage accounts. And they're going to eventually be required to do an inventory. So in a regular estate, the inventory in Maryland is due within 3 months, 3 months of the date of the letters of administration. So that's where we're going to tell the Register of Wills exactly how much everything is worth. Now, there are alternate valuation dates, and this has to do with taxes. We're not going to spend too much time on that. And that's 6 months from the date of death. And also note that the claims of creditors period, the claims against the estate period, is 6 months, and that's also from the date of death, not from the date that the estate is opened. Now, for those of you who have been executors or personal representatives before, you may have experienced that a Register of Wills in Maryland, a certain Register of Wills in a certain county, you may notice, if you haven't, you may in the future, that not all of them follow the same set of rules and guidelines. So some of the registers of wills, the offices are different. Some of the orphans courts, which are the ancillary court that's connected to the Register of Wills, some of those courts are different or more conservative than others. And all counties in Maryland have a Register of Wills and an orphans court, except for Harford County and Montgomery County, where the circuit court sits as the orphans court. So the reason I bring that up is do not be surprised if some of the interpretations of these rules end up being slightly different, but largely this is the straight and narrow path that you should stay on. Spouses, this is for married individuals who pass away. There is a spousal election period, and there is a new augmented estate, and we don't have time to get that into that today, but there's a new spousal elective share law as of a couple of years ago, and that governs how much a surviving spouse is entitled to. So we need to be aware of that, although in the vast majority of cases for married people, the person who passes away is leaving almost everything to the surviving spouse. Tax elections have to be made. So we're going to talk about the disclaimer. The disclaimer is a tax election. It has to be made for federal estate tax purposes. It has to be made within 9 months of death, but for other purposes, it doesn't have to be limited to 9 months from the date of death. A disclaimer is when a person receives an asset but then disclaims it, and it passes by operation of law, or it passes through the documents as governed by the terms of the documents. The federal and state estate tax return is due within 9 months of the date of death, or although it can be extended, but all taxes have to be paid, or should be paid, I should say, to avoid a penalty within 9 months. And we're going to keep going down this list now as we continue the legal step-by-step process. Other tax elections include the Q-tip election, qualified terminal interest property. This is the election that is made on Form 706 also. Connected with, as far as I'm concerned, is the portability election, which is also made on the Form 706. And as of the time we created this webinar, we haven't yet updated this. The federal government just extended the time for the portability election to 60 months or 5 years. So when the portability idea first came out, and portability, by the way, if you are not familiar with this, if a married person dies, their surviving spouse has the right to port their exemption amount, their federal and state exemption amount. And right now, the federal exemption amount is $12,060,000 per person, unprecedented amounts, huge amounts. The Maryland exemption is $5 million per person. And the surviving spouse can make what is called the portability election. And that election is made, and now it is made within 60 months, a long, long time for the surviving spouse to be able to make that election. So please correct that on your notes. It should be 60 months, and we will make that correction here because it just recently changed. But the point I'm trying to make is that these are important tax elections for married individuals. The portability election, the Q-tip election, this is where someone has left a marital trust, usually for a surviving spouse, and the marital trust is usually used for asset protection and also for remarriage protection to make sure that the assets go downstream to the children or other beneficiaries. And in a regular estate, the first administration account is due within 9 months, 9 months after the issuance of the letters of administration. Now, there may be a second accounting that's due if the estate continues to go on, or a third accounting and subsequent administration accounts. But eventually what happens is the personal representative is released from liability because the court is ultimately going to approve the final accounting. Now, let's talk about this issue of liability. And we're going to talk about that in the trustee context in just a second. So let's say that you are administering an estate and there is an issue that comes up. It has to do with the sale of a house, and some of the beneficiaries don't agree that it should be sold, or there are huge repairs that have to be made, or my point is there's a circumstance that may indicate conflict. Remember, as a personal representative, you can always petition the court to get the court's approval for what you are doing if there's anything that is controversial. And that way you are getting the court's seal of approval on what you're doing, and you're not going to leave yourself exposed to liability. So we want to minimize liability for personal representatives and trustees. And for example, when Elville and Associates represents a trustee or a personal representative, we are, as our highest priority, our goal is to make sure that the personal representative or trustee is walking down the narrow path that they're supposed to, that they cannot be removed for a breach of fiduciary duty, and that we are minimizing their liability and exposure. So that is a very important thing to keep in mind. Now, retirement plan accounts, whether we're dealing with an estate or a trust, which we will see in a few minutes, retirement plan accounts have to be claimed, and there's a certain timeline for that. So let's just talk about Uncle Sam's rules, the IRS's rules for this. Remember, retirement plan accounts, IRAs, 401ks, 403bs, 457 plans, all of these types of plans are retirement plans. The most common, of course, is IRAs. So let's just talk about IRAs. IRAs have the following timeline, and we can talk about this more on an individual basis. By September of the year following death, by September, and I believe it's the end of September of the year following death, and that's a long time for some people. So let's say a person died in January. The September date that I'm talking about would not be until the year following death. That is when the beneficiaries are actually finalized. And there's a reason for that that we don't have time to go into today. Then by October 31st of the year following death, that is when plan documents have to be submitted. So let's say that someone had passed away and they had left an IRA to a trust. They had left an IRA to a trust for a child or for a special needs child. That plan, that document, I should say, has to be distributed or given to the plan custodian by October 31st of that year. And what we're doing here is we're making sure that we're satisfying the trust rules called the see-through trust rules. And this is all a big subject. That's a subject of another conversation. But the final process in that year after following death timeline is December 31st of the year following death. And this has to do with all the IRAs have to be broken out if there's multiple beneficiaries. All of those IRAs have to be separated by December 31st of the year following death. So there are circumstances where the beneficiary designation has to be either finalized or the beneficiary has to be satisfied by that time. For example, let's say that someone, and this is a larger subject, but let's say someone had left their IRA to a revocable trust. It was actually going through a revocable trust. And I know here we're talking about estates, but I'm just giving you a bit of background on this. And let's say there was a charity in that revocable trust that was to get $10,000. An example of the September deadline is that if we satisfy that charity by September of the year following death, it wouldn't have a negative effect on the rest of the trust, as sometimes leaving an IRA into a revocable trust does sometimes cause problems. The October 31st deadline is where we are leaving an IRA to a trust established under a will or trust, and now we have to satisfy the custodian by providing the document to them by October 31st. The December 31st guideline has to do with simply making sure that no matter whether there was a trust or whether there were individuals that were beneficiaries of an IRA, that the IRA is properly broken out into separate IRAs by that time. The Secure Act, and we're going to take a break here in just a second and ask for questions. The Secure Act, of course, was signed by President Trump at the end of 2019, and it became law January of 2020. It affects how retirement plans are done in this country, and also for healthy individuals, it affects how they can only take those assets over 10 years. And most of you on this webinar probably are familiar with that now. Healthy beneficiaries, those without disabilities and so forth, they can have only 10 years to take those plan assets out of the plan and pay taxes on them. But as fiduciaries, you would be aware that there are 5 exceptions to that. And by the way, the IRS has new temporary regulations as of February 2022 that clarified a lot of things, but the regulations continue to be in process, so we have to be aware of that. But back to the 5 exceptions. So spouses are exempt from the Secure Act. Siblings or others who are siblings who are less than 10 years younger than you. So let's say that older siblings of the person who died or siblings who are less than 10 years younger, those siblings are exempt. Minor children are exempt. Chronically ill people are exempt, and their special needs trusts are exempt. And persons with disabilities as defined by the Secure Act are exempt, and their special needs trusts are exempt. So as fiduciaries, we have to understand this, because remember, I just really shifted gears on you from probate assets to non-probate assets. So the person who died with or without a will, and they had probate assets, you as the personal representative are administering that estate. However, that person in my example has IRA assets, and those are non-probate assets. You still as a personal representative have a responsibility, or arguably a quasi-responsibility, to manage and to make sure those claims are being made by the beneficiaries. And it's a very strange concept there that you have this quasi duty, but those assets are really not in probate. And we're going to talk about inheritance tax and how that can affect you as a fiduciary when you are dealing with non-retirement assets and retirement assets as part of a probate estate, even though you're really just tasked with administering the probate estate, which is the non-retirement assets. So with all that said, we're going to go to the next slide. And we're going to stop just for a second. Jeff, I've been going for just a little while here, and we got started a little bit late because of the technical difficulties. Are there any questions? And I'll just stop for just a minute.
Well, thanks, Steve. We do have one question from our friend Karen. And she says, if someone disclaims, can they identify whom the disclaimed asset goes to?
Yes, thank you, Karen, for that wonderful question. And the answer is yes. So in a pure disclaimer type situation, the disclaimer takes place, and if there's no mention in the documents, then it's going to go by operation of law, as if the person who had disclaimed had predeceased the decedent. But to answer your question, the person who died, the decedent, they can name the person to whom disclaimed assets go, and that's exactly right. They can do that in a document.
Okay, that is everything for now.
Thank you, Jeff. So in the interest of time, I'm going to keep moving forward as we continue the legal step-by-step process in probate. There has to be a fiduciary income tax return. Uncle Sam wants to know, from the decedent's date of death until the time of distribution, who is going to pay that tax and what is the tax? So remember that at a person's passing, their assets continue to exist. They are in bank accounts, they're in brokerage accounts, they're creating dividends and interest. And you as a fiduciary have to file a 1041, what we call a fiduciary tax return. And that tax is due, and that's part of your fiduciary responsibility. So we want to make sure we're taking care of the decedent's final tax return. We also want to make sure that we're dealing with the estate tax return, meaning the fiduciary tax return for the estate. But also, if the decedent had a taxable estate, an estate that exceeded Maryland's exemption amount or exceeded the federal exemption amounts, that we are filing a Form 706 for the federal and also a Form MET1 for the Maryland estate tax. And also, even if the decedent did not have a taxable estate, but they were establishing a marital trust, we would need to make the Q-tip election on Form 706. We would also need, if the person was married and it was appropriate, we would also want to make the portability election on the Form 706 and MET1. So these are, in essence, the concept of what we want to be thinking about as an executor. And again, I'm going to go back to these checklists. If you will take this presentation as a kind of a mini masterclass, like a mini tool, and you compare this and juxtapose this with the checklist that we've provided for you, it's going to give you real insight as to how to start viewing a probate estate before it begins. And of course, most of the registers of wills are very good, and they will provide you with a checklist of their own. It won't be this detailed, but it will be a good checklist, and you'll find most of the registers of wills and their staff to be very helpful. All right, now in the interest of time, we've been going about 50 minutes. I'm going to switch to the non-probate process. What is the legal step for the non-probate process? Well, not surprisingly, this is going to be very similar. So let me give you a quick example. What is non-probate? Well, it could be someone who had passed away with only transferable on death designations. I'm leaving all of my brokerage account transferable on death to my beneficiaries. Well, there's no probate there. It's very simple. But there's reasons why most people would not rely on a transferable on death designation or a POD designation as the full-blown estate plan. Most people are going to use wills versus trusts, or trusts, I should say. So let's assume that we are dealing with a fully funded revocable trust. Now, here's that trust, if you can imagine. It's this circle that I'm drawing with my hands. That revocable trust is fully funded with assets. There's no probate at all. There are IRA assets that are properly beneficiary designated. And the person who died only had one child. They had one child, and that child is taking care of everything. Well, to me, that is the quintessential perfect plan. Not that everybody only has one child, but in that scenario, where I'm trying to go with that is that one child has a very straightforward process. If there is a single person or a surviving spouse and they die with that one child, a lot of the things that we're talking about here in this process are greatly simplified. And theoretically, that child can distribute everything to themselves from the revocable trust immediately, in theory. And in reality, they can actually do that. But probably they would want to walk through a pretty simple steps, a series of steps to make sure that the decedent's personal tax returns were filed, that there are no creditors, and really walk through a very simplified process. My point there is, with an only child situation or an only single beneficiary situation, a revocable trust can be very powerful, and a lot of this process that I'm talking about would not really be needed potentially. But where we have surviving spouses and where we have multiple children, even though we don't have an estate administration, even though there is not a full-blown accounting required, a good fiduciary is going to look at this process and say, I'm going to provide an accounting. I'm going to walk through the steps, even though there's no probate. I'm going to walk through similar steps because I have fiduciary responsibility. I have to account to other people. I'm going to ultimately provide them with an accounting. What happened from the date of death? What happened to the retirement assets that I'm helping to facilitate claims on? What happened with all the expenses? What happened with all the income? What happened with all the tax returns? What happened with the repairs to real property? Everything is accounted for, and then final distribution is made. And of course, the person who is administering a revocable trust, which is what we're really talking about here, non-probate, that person doesn't have to march to the beat of the Register of Wills drum. They can take their time, or they can hurry it up as much as they want within reason. And my point is, we get to a point of distribution, and then that person is going to want to get themselves released from liability, which we're going to talk about here. But my point of this is, we don't distribute assets until we have a release of liability and we have everything accounted for, and the beneficiaries generally have signed off. They have been aware of the accounting, and they give their consent, and they release the fiduciary from responsibility. So with that said, let's briefly go down this list again. We're doing the same thing in estate planning as we're doing in trust planning. Here in trust planning, we're still getting date of death values. Why do we have to get date of death values? Well, we want to make sure that we've established a new cost basis. Okay. Now, retirement plans don't have a cost basis, but we want to make sure that we've established for the non-retirement assets cost basis information for step up in basis purposes. We also want to provide it for federal and state estate tax purposes and for other reasons. So date of death values are very important to establish the beginning value of the accounting. Beneficiaries now in Maryland are entitled to notice. So certain beneficiaries, called qualified beneficiaries, since 2014 are entitled to notice, and they are entitled to information, for better or for worse. So generally, this is a good law. And prior to 2014, beneficiaries in Maryland had no right to information. They had no right to notice. So that is a fiduciary responsibility, and it is something that you must do so that you don't breach your fiduciary duty, where you could be removed as the fiduciary. Creditors can be given notice, even with a revocable trust. Now, most people who pass away don't have creditors, but many do. So the idea here is to simply use the statutory notice provisions. There are notices, right? There's a notice right in the Maryland Code. And in my view, the highest and best thing to do is to provide notice to creditors, even though it seems counterintuitive, where someone may say, well, this person had no creditors, and it's a waste of $300 or $400 to publish notice. But the reason I like it is you as a fiduciary are now exercising the highest and best form of your duty by giving that notice. And basically what you are saying is, if you don't bring a claim against this trust within 6 months, then you can never make a claim again. So to me, it is the highest and best thing to do, and it shuts off the ability, forecloses the ability of a creditor to make a claim after 6 months. Again, same situation. We have alternate valuation dates for tax purposes. The spousal election is available. Now, this is another part of our slide that I want you to update. That spousal elective share, the new spousal elective share, has been implemented, and it has two features. It has an elder care feature where it has a certain provision that allows someone who has a spouse who is impaired, and that spouse that's well passes away. There is a technique where assets can be left for the benefit of a disabled spouse, and if you are the fiduciary handling that trust or estate after the death of a well spouse, which sometimes happens, you need to know that Maryland has no right of recovery against the estate of the ill spouse. So that's one aspect of the new spousal elective share law. The other aspect of it is, as you saw on the estate administration side of this presentation, you saw that spouses that are survivors, they have certain spousal rights, and that has to be taken into consideration, especially if there is a situation where someone dies, they're married, but they're not leaving all their assets to their surviving spouse. So in that circumstance, we have to carefully look at the new spousal elective share law, and that new spousal elective share law is formulaic, and it's going to tell us as fiduciaries, do we have a big issue here? The survivor was entitled to a certain amount, but the person who died did not provide for that bare minimum amount, and now the survivor has the right to make an election against the trust or estate. So we have to be aware of this. The Q-tip election and the portability election, these are very similar to what we talked about earlier, except we're dealing with a revocable trust administration and not an estate administration. Disclaimers, same situation. You have 9 months to make a disclaimer for federal estate tax purposes. We need to continue to understand that just in case there is a survivor, a surviving spouse, and a disclaimer needs to be made for estate tax purposes. Now, usually this is not the case today if there was a surviving spouse, because most people have far less than $24 million, most people. Now, of course, there are many people that do, but if we have portability, we have that $24 million of exemption, and we have $10 million for Maryland. That's more like a blanket of protection from estate tax, which is 40%. It's very significant, but that blanket of protection through portability probably means in most circumstances a survivor does not have to make a disclaimer for tax purposes. And that's something we could talk about on an individual basis. The Form 706 or MET1 would be filed whether there needs to be a Q-tip election, whether there needs to be a portability election, or whether there is a taxable estate of over 12 million or 24 million or 10 million for Maryland, 5 million for individuals. Retirement plans, we have the same timeline, the fall of the year following death. The Secure Act, we have the same provisions. There are some aspects of the Secure Act rules that might affect a surviving spouse. Surviving spouses are exempt, but if the deceased spouse leaves assets to a Q-tip trust, to a marital trust, or a non-marital trust, the Secure Act provisions are going to possibly say that the surviving spouse is no longer exempt from the Secure Act. And we as estate planners during life have to make sure that we don't want to disqualify, unless we're intending to, we don't want to disqualify a surviving spouse as an exempt beneficiary under the Secure Act. Now, as I mentioned earlier in this particular segment, if we are a fiduciary in a non-probate administration like a revocable trust, we're going to want to, as the highest and best practice, we're going to want to get a release, waiver, and even a refunding agreement from the beneficiaries. We want to be released from liability. We want to have everything accounted for, everything transparent, And of course, all situations are different, but in a perfect world, in a general world, we want to make sure that we're being released. We don't want to distribute money to beneficiaries who could then turn around and sue you for some kind of breach of duty or some kind of theory or cause of action that they have against you. We want you to be released. Same situation with probate. We want to have fiduciary income tax returns, the Form 1041. We want to file the decedent's final tax return. And in the world of the IRS and estate tax, we want to make sure that there has been estate tax, whether it's Maryland, the Comptroller of Maryland, or IRS. We want to make sure that there is a closing letter. And one of the things I want to throw out here is I've kind of leapfrogged over this issue. When we open an estate or we're administering a trust for a decedent, we want to make sure that we check with IRS and the Comptroller of Maryland to make sure there are no open tax balances, that taxes have been filed, tax returns have been filed, that the Comptroller and Uncle Sam, who are super creditors in the sense of they are entitled to be paid any outstanding taxes, and we as fiduciaries don't want to be responsible for distributing an estate where there are tax liabilities. So we want to make sure those, generally speaking, there are exceptions, but we want to make sure the tax liabilities are satisfied. Jeff, I'm going to stop. We're about 10 or 15 minutes to go in the presentation. I want to see if there are any questions at this point.
Thank you, Steve. We do have a few questions. A couple from our friend Kelly. And first one is, just to clarify, portability is available for the surviving spouse when considering the 5 million Maryland asset equivalent?
That is correct, Kelly. Thank you for that question. So Maryland has adopted portability. So a person who is electing portability, they should, in my opinion, also elect it for Maryland, and Maryland does have that.
Okay. And another one from Kelly. Also, how does one handle the difference between the Maryland estate tax threshold and the federal exemption equivalent?
That's a great question. Now, that's going to be something, Kelly, that's on a case-by-case basis, because someone who has, a taxable estate, so to speak, of over 5 million for Maryland, or if it's a couple, over 10 million, or a person who has assets that exceed the federal threshold, and that juxtaposition between federal and state is going to be a question of what kind of assets that person has. For example, a person with lots of retirement assets that are causing a taxable estate, there's not a lot of things we can do to minimize tax. For example, we can't gift those IRAs, we can't discount the value of them and so forth. So versus another person who has real estate, or they have other assets that are more flexible, so to speak. There are certain techniques that can be used to plan for those differences. There are different ways of dealing with those differences in the documents for married people. There are ways of dealing with this through gifting and understanding that Maryland has no gift tax, but the federal government does. So how do we think in terms of that? Uses of life insurance to deal with the state tax. So lots of ways to do that, but that is a big issue for that person.
Okay, thanks. And we have a couple comments from our friend Barbara. One here who says, the first, you just made me realize why we need an attorney to help go through this, so many things. And the second is a question, do you notify our CPA of what we need to file, or do I assume that they know what needs to be filed by them on taxes?
Thank you for that wonderful comment and that wonderful question at the end there. The issue there with CPAs is going to be a question of what kind of CPA. So as a young lawyer, I learned that there are many, many different types of CPAs that handle various types of work. The estate and gift tax type of CPA, the person who understands that, the persons we work with, they understand this, and we don't have to tell them anything, and we work with them collaboratively. Whereas someone who has a longtime family CPA and the survivors wish to continue using that particular person, that person may or may not have this threshold of knowledge and might have to be brought up to speed. But collaborative work together with that team is the key there.
Okay, thank you, Steve. Those are all the questions for now.
All right, so as we start to head down the last part of our presentation, let's talk about the practical steps. We've talked about legal steps, we've talked about examples, we've talked about a broad subject matter, giving you a general idea, but let's talk about practical steps. So we want to schedule a meeting with the fiduciary and the professional team, if it's not a professional fiduciary that's handling this, within 30 days. Again, this is going to vary. We want to be respectful of the survivors and their loss, but generally speaking, we probably wouldn't want to go more than about 30 days because of the processes that need to start happening. We want to coordinate with all the advisors. I know I'm being redundant about that, but it can't be overemphasized enough. We want to use the checklist and be aware of critical dates. The last thing we want is for you to be a fiduciary. It could be your loved one, and now you've missed dates or you've left yourself open to the criticism of others who could ask for your removal. We don't want to do that. It is a very big fiduciary responsibility. It is a thankless responsibility in many ways, and we want you to be organized. And I go back to the beginning of my presentation. You are orchestrating a symphony, whether you like classical music or not, so to speak. You are preparing to paint or to work with a composition, and that composition is this administration. And you have to take it methodically to make sure that you're not leaving yourself exposed to liability, that you don't miss something, or that you don't hurt one of the beneficiaries inadvertently. And all of that is part of the process. We want to have an inclusive process. Now, this has to do with this issue of information. It has to do with beneficiaries being entitled to notice. And it has to do with, well, what if we don't have everybody on the same page? What if there is a beneficiary who's difficult, or they threaten others, or they are not responding? Well, generally speaking, you want to try to include people to try to keep down tensions. And of course, certain people are entitled to information, certain people are not. So the big judgment call sometimes in administration is, do we provide information to people who otherwise are not really entitled to it? And sometimes that's a strategic move to try to keep people happy. The idea here is reasonableness and trying to make sure that the fiduciary is protected and that they are making common sense decisions. Now, again, common sense is helping a surviving spouse or other survivor to cope, taking appropriate actions in their support. Again, we're not hurrying, but we are encouraging surviving spouses to be methodical. Some surviving spouses, and maybe there are some on this workshop this morning, have really put themselves through a lot. You know, they come to an attorney or their fiduciaries and their advisors, and they really try to get their own planning in place very, very quickly under very difficult circumstances. I'm very much aware of that, and I've worked with many surviving spouses, but we just want to not have to do that too soon. We want to make sure you take care of yourself first. Organization and general readiness are the watchwords. Document storage. Now we're talking about the decedent has not died in this slide. The decedent is alive. The decedent or their trusted loved ones, their children, their siblings. We should help people get organized and get ready. All that's going to do is nothing but positive things. It's going to save money in the administration process. It's going to make the life of the fiduciary much easier. Organization and readiness through document storage, records, statements, trying to get things as organized as possible, making sure that if we're going to have a probate estate, making sure that someone understands their duties and where the assets are, and that all the retirement type assets have beneficiary designations. If we're going to have a non-probate estate, to make sure double and triple and quadruple check that the revocable living trust is fully funded. Business assets, which we didn't really talk about today, LLCs need to be assigned to avoid probate. Now, there is a new LLC law that you should be aware of that'll take place October 1st, where an LLC can actually be a dispositive instrument. It can actually provide for where the assets go. But a lot of old LLC operating agreements and so forth are going to provide that don't have that provision are subject to probate. So we want to make sure that corporate interests are not subject to probate. I've seen situations where $5 to $7 million that should have been outside of probate was actually included in probate because LLCs were never assigned to the trust. So we want to make sure doing our due diligence during life and the use of archives and other storage instruments. Now, as we wrap up, what are the most significant legal and tax issues? So again, I just mentioned this, the titling of assets prior to death. This is really the question. If we were to stand back from all of this information today and simply ask ourselves, what is one of the most, if not the most important thing in all of estate planning, we might be able to boil it down to this question. How do you own your assets at the time of death? If you can tell us, or you tell someone tells you, this is how I'm going to own my assets at the time of my death, that's going to tell us everything. How are those assets titled at the time of my death? So we need to focus on titling, need to focus on, for example, those LLC assets. We need to make sure that are we joint owners? Are we not joint owners? How are assets going to flow at the time of our deaths? We absolutely need to make sure that our retirement plans are beneficiary designated and those beneficiary designations are appropriate. The valuation of assets. This is something that if we approach it as a methodical process, that's going to be taken care of and you're going to not be held responsible for failing to properly value the assets. Caution in retitling assets. This is something that I see a lot of. I see well-meaning people, well-meaning fiduciaries, well-meaning financial advisors quickly retitling assets after the death of a decedent, or someone like a surviving spouse accepting the proceeds of life insurance before we've considered whether or not the life insurance needs to be disclaimed, or back to the retitling of assets after death, a financial advisory firm and the fiduciary retitling assets so quickly that the decedent's wishes were not carried out. The assets were titled in the name of someone outright, where the decedent said they should be titled in a trust for the person's protection or for divorce protection, remarriage protection, all of those things. So we have to be cautious here not to act too quickly. Inheritance tax. We didn't talk much about this. I'm going to take 1 or 2 minutes on this. Inheritance tax is a big issue. If we have people who are non-lineal descendants, and a good example is nieces and nephews, someone is receiving assets from the decedent that is beyond, excuse me, I should say a niece or nephew or someone beyond, a friend, someone that is subject to inheritance tax. And in Maryland, the inheritance tax is 10%, and Maryland is one of the only states left that has a state estate tax and an inheritance tax. That's where we live. We have to, as fiduciaries, be aware of this. Here's an example, and here's a pitfall. Someone dies, and they have assets going to someone who is subject to inheritance tax. You as the fiduciary are involved, and the person who is receiving assets, who is subject to inheritance tax, is receiving, let's say, assets from an estate or trust, but they're also receiving assets from a retirement plan. And you, as a conscientious fiduciary, you marshal those assets of the retirement plan very quickly. You help the beneficiary make a death claim on those assets, and now the beneficiary has officially taken those assets, and let's say they've done it fairly quickly. All the while, you're still administering the estate or trust for many months. Now, whether you knew it or not, you just set up a situation where, through no fault of your own, that person now is subject to inheritance tax on that IRA money they just received. And you are responsible for making sure that you reported that non-retirement asset to the Register of Wills. So there's a form, it's basically called fixing the inheritance tax on assets that are really not in the probate estate. They are in non-probate. And that's your responsibility as a fiduciary, because the Register of Wills collects inheritance tax. So you've got to be careful with that to not get yourself in a bind where the estate or the individual is subject to a penalty, very great penalties for not paying the inheritance tax, because you're also going to submit information to the Register of Wills or to, the Register of Wills later when you administer the estate or trust. So you've got two situations here where inheritance tax is due in different times in that situation. So you have to be aware of the inheritance tax. Whether the beneficiaries are apportioned and they have to pay the inheritance tax, or whether the trust or estate, no apportionment, is paying the inheritance tax. Portability election, Q-tip election, we talked about that. Failure to foreclose creditor claims. So we don't want to do that. We want to go ahead and take the leap and make sure if we are administering a non-probate estate that we give notice to creditors, even though it may not make sense sometimes, because that's the highest and best form of protection, in my opinion. I leapfrogged a little bit over portability and the Q-tip election. These are the problematic issues. We don't want to miss the portability deadline if we are a surviving spouse. Many instances, it's going to make sense to elect portability, and now we have 60 months, which is wonderful. However, not everybody will need to elect portability. Not everybody will think it makes sense. I think it makes sense in most cases because the government is slated to lower the exemption amounts from the $12,060,000 adjusted for inflation down to about $5.5 million adjusted for inflation in 2026. So we want to be careful, but the good news, we have 5 years to make that decision. The Q-tip election, it must be made on a timely basis, so we need to make sure as fiduciaries that we are doing that. So again, how can financial advisors and the team all work together? CPAs, attorneys, personal representatives, and trustees at the time of crisis. Again, during life, we want to do a lot of work to communicate. We want to establish who's the quarterback. There are sometimes quarterbacks that will emerge from the pack, but we don't want that. We kind of want to establish this in advance. This is not an easy thing to do. This is something that takes a lot of thought and purpose during lifetime. If the decedent has not done this during lifetime, then I think it's incumbent upon the professionals and the fiduciary themselves to say who is going to lead this group, who is going to coordinate this group of the attorney, the CPA, and the financial advisor. Again, we want to be very careful if we are the financial advisory side not to retitle assets too quickly for legal purposes. So again, we want to invest significant time during the lifetime of the decedent, make sure everything is organized and properly aligned. This is why we have a client care program. This is why we encourage clients to participate in a process where situations are evident, like an illness is present. We want to expedite things. This is common sense, but sometimes it doesn't happen. I've seen situations where someone did not get their plan expedited soon enough, and we don't want to be in that position. We all want to work in coordination to make sure that someone who's passing away or is ill, that their objectives are achieved before they're passing. My experience has been if someone has an illness, many times they can pass much quicker than we think. So we have to be aware of that. And we want to ascertain someone's wishes. We want to encourage them to use a memorandum of intent. Again, I'm repeating myself intentionally here. Organizational tools during life, education of family members. We do a lot of that at Elville & Associates. If you are a fiduciary, I strongly recommend that you educate your family members. Systematic approach and reporting about how things are organized during life. I know we've talked about that. We want to disseminate information quickly. And if our team is not cooperating, we need to redo that team. Whoever is the fiduciary has that ability to hire professionals. If you're a fiduciary and your professional team is not collaborating, you need another team. And that's a tough statement, but we need to make sure that we as professionals are working in the highest and best way with fiduciaries. And we want to instill clients and instill survivors with the confidence that things are in working order. And if they are not in working order, we want to do our best to be a support to the survivors and make sure that we get things in order as soon as possible. I've been a little bit long in this presentation. I apologize about that delay earlier, but we want to suggest an educational path forward. And we want to say, listen, if you are administering an estate or anticipate that you're going to administer an estate, we are here to consult with you. If you're administering an ongoing trust, which we didn't talk about today. Today, we're talking about the post-mortem process. But if you're administering an ongoing trust, our Waypoint Fiduciary Services LLC. That is our trustee arm here at Elville and Associates. We do administer trusts and we provide support to trustees, trust protector services. And if you don't know what a trust protector is, we could talk about that at another time. But we want to look at all of the assets, all of the facts of the situation, and provide support. There's nothing to fear. If you are a person who is simply trying to, as I know almost 40% of you are on this workshop today, if you're trying to get a handle on the entire estate planning process, including how much it's going to cost at the end of life, and incorporate that all into the 3 major phases, that I really salute you for that. So if you'd like to discuss that, the idea is keep your estate planning current during your life. Join our client care program. It's really just for the purpose of facilitating participation and trying to make sure that clients follow up. We also have fun at the same time. We're getting ready to have a wine event at the Boxwood Winery in Northern Virginia. But those are just the ancillary benefits. The education and updating is really what the client care program is all about. Make sure you have an advisory team. And if you have one, I would advise you to think in terms of how can I make this thing work for me the best way possible? Are my advisors really communicating, and do they know each other? Should there be a meeting of the advisors just as a preliminary thing? Bring questions or concerns you have, and our goal is to give you time to think with our facilities and our state-of-the-art equipment that we have here. We want to know what your goals are. We want to help you get there, and we want to educate. So I apologize. I've gone maybe 5 minutes longer than I anticipated. Jeff, I'm going to turn it back to you. Thank you for your time and attention. I hope you have a wonderful weekend.
Well, thank you, Steve. Great information as always. This, as you mentioned, is certainly one of our most important presentations. Speaking for myself as somebody that just had a loved one pass away and being named the executor, I don't know how I would do this on my own. So I listened intently again, even though I've heard it many times, and I'm very happy to have some support in this type of situation. So great information. So let's go ahead and answer. We have one question here. It is a good question and something I think a lot of people would not know unless the question was posed. So thank you. The question is, my loved one is still living. I'm her power of attorney. Do I lose this status once she passes? Her deceased spouse wanted things a certain way.
Thank you so much for that question. And the answer is yes. It's so hard to keep all of this in perspective. You know, we were talking about today, what if a person passes away, but we were also doing a lot of talking about what happens during life and what should we do. Your question is an excellent one. You have a power of attorney document. You are the agent, and the person who signed that power of attorney is the principal. And you have the powers under that document. And when that person passes away, your power is a lifetime power, so that power goes away. So the power of attorney document dies with the person, and now your authority will have to be reestablished if you are the named fiduciary, either as a personal representative of the estate of the person or a trustee of the trust of the person. So that's a great question. Your authority would end under that power of attorney at his or her passing.
Okay, very good. So now would certainly be the time to get any last questions in for Steve. We did talk about during our minor delay there, the upcoming webinars in our webinar series. I will be sending out a follow-up email with a little bit of supporting information. I'll send out the video link as well as our materials again for anybody that might not have received them the first time for some reason. And looks like we do have one more question here. Are you aware that banks may ask you to complete their power of attorney forms? How do you handle that?
Thank you for that question. So briefly, yes. So we're living in an age where people want to do belt and suspenders due diligence to make sure they don't have liability. So you go into a bank and you have your powers of attorney, which could be a Maryland statutory power of attorney, or it could be a non-statutory power of attorney, like a general power of attorney, and that should be sufficient. There's no question. The Maryland statutory form, if you have that, that is enforceable by law. The bank has to accept that. Now, let's say you don't want to waste a lot of time or energy and you just say, fine, I'll sign your specific power of attorney on that bank account. Well, that's not a bad thing, as long as you agree with that agreement that your agent can walk into that bank and deal with that specific account with that specific power of attorney. But my argument would be, why is that needed if you have a general or statutory power of attorney that is a very broad power of attorney? So as long as the specific power of attorney is not contrary to your intentions and you feel okay about it, and the bank will accept copies of your other powers of attorney, which they should approve within 72 hours, I think that's okay. But if it isn't consistent with your wishes, then I think what happens is we should look at that power of attorney, talk to the bank, and get past that obstacle, because we all know at banks there are various persons that rotate and they have various points of view. Some have experience, some don't, and we'll get past that issue one way or the other.
Okay, great question. Okay, well, we're at 11:31, so thank you, Steve, for being here today. Appreciate all your time as always, and thanks to our attendees for their questions and for your interest in our webinar series. And if we can do anything for you, as always, feel free to email me, fill out our survey if you're interested in a consultation, wanting to speak with Steve for any reason, and we'll be happy to be a resource to you as always. So thanks for being part of our webinar series, and have a wonderful weekend.